morning, everyone, and thank you for joining us at our Prestige PEO webinar series. My name is Carrie Kaiser. I'm Senior Marketing Operations and Event Specialist at Prestige PEO and your host this morning. Today's webinar will cover the intersection of the ADA and FMLA and practical steps to achieve compliance. Joining me today are Liz Shaw, VP General Counsel, and Megan Siegel, Corporate Counsel. Our webinar audience members are muted by default. However, we encourage you to make use of the chat feature, and we will respond to them towards the end of the webinar, time permitting. If we're unable to get to your question, we will reach out to you shortly after the webinar concludes. Additionally, the webinar is being recorded and will be made available on our website at prestigepeo.com/webinars for your reference at any time. And now we'll get started with the webinar. Welcome, Liz and Megan.
Thank you for the introduction. I'm ready to talk about today's webinar. Megan, thank you for joining me. As we talk about FMLA, ADA, and the Pregnancy Workers Fairness Act and how all these things kind of work together. And so let's talk about our agenda for the day. So first and foremost, we're going to be talking about FMLA. We have a lot of small businesses that are right on the cusp of having to comply with FMLA. They're not always, aware of the logistics of it, how it works, what makes an employee eligible for it. And really, even if you are an employer who's had to do FMLA for a long period of time, sometimes there are some landmines out there that you want to watch out for. So we're going to be talking about those issues today to make sure that you are doing all the things that you need to be doing as an employer. And we're also going to be talking about how that intersects with the Americans with Disabilities Act and what that is, how these leaves and other federal laws play together, what the responsibilities are as the employer to engage in the interactive process, and what really puts you on notice as an employer that you need to be offering a potential accommodation to your employee. And then the Pregnancy Workers Fairness Act is a new law that just went into effect recently, and it comes with its own nuances for us to navigate. So we're going to be talking about that as well, just to give you some basics on it and how all these things interact and play together. And then we would be remiss if we didn't also talk about the fact that each state kind of likes to do their own thing, and sometimes they want to give more rights to employees and certain benefits to them that aren't required on the federal level. So we're going to talk a little bit about how all these things play together. So thank you, Megan, so much for helping put this webinar together today, and let's kick it off and get into it.
Yeah, well, for starters, we use the acronym FMLA all the time, but what does that actually stand for? And that is the Family and Medical Leave Act, and it's a federal level protection for employees, for qualifying employees, I should say, who may need to take some time off of work.
That's right. And Megan, hopefully we can all hear you okay. If you could speak up a little bit, I think that would be helpful for me. And I think some other people also are having a little bit of a hard time hearing as well. So I'll let you play with that while I do the next slide. How about that? There we go. So what does FMLA provide? Just on a very high level, it is unpaid leave, but it is more importantly job protected leave. And so that is one of the most important takeaways from FMLA, is that basically once FMLA is completed, that employee still gets to return to their job or an equivalent position, and they're not going to be terminated or dismissed in the event that they need to take this leave. It also provides for some benefit protections in terms of being able to continue those benefits even though they're not working. And then, of course, that job reinstatement that I already referenced. But FMLA itself can range anywhere from 12 weeks of leave to 26 weeks of leave, depending on what the leave is for. If it's a military leave situation, that's where we see that 26-week leave come into play. But typically, for most employees, they're looking at 12 weeks, work weeks of FMLA. It's really important to just keep in mind that anytime an employee is using FMLA or trying to, take advantage of that, federally protected benefit, that there's no retaliation or interference with them being able to take that. That is their right as an employee. And then the difficulty and inconvenience to the employer is ultimately irrelevant. And I always think in terms of really practical, real life experience. Years ago, I worked for a company, and my team had a lot of females who were younger, starting families, and at least 2 a year would be going out on FMLA to have, babies and starting their families, which is, really exciting for them. But for the rest of us on the team, sometimes that was difficult and inconvenient to be able to cover their work while they were out. But it was really important as an organization to really set that tone that we support the rights of the workers to be able to take the time off, that we try our best to enable our team to fill in those gaps, and that we, really understand that this is just part of working in a company where there's going to be times where people are out and others may have to step in. And I think being empathetic to those who maybe face an additional workload or some additional tasks is important, but it is really important to make sure that any feelings of inconvenience or difficulty is not then taken out on the employee who is entitled to those rights. So that's, I think, just some important things to keep in mind. So Megan, I think you sound a little bit better. So let's let you take back over and explain the eligibility for FMLA.
Certainly. So I know I also struggle sometimes with technology and getting my audio to work, so my apologies, everyone. So for employees that would qualify under FMLA, there's a bit of a 5-step qualifier to look at. So first, the employee would need to have a qualifying experience for needing the leave, which we'll go into shortly. FMLA does apply to private employers with 50+ employees or a public employer of any size. The job site would need to have 50+ employees within a 75-mile radius. The employee themselves would have to accumulated 12 months of working for their employer. There's a few nuances and caveats there, but ultimately it's that 12 months of service to the company and have worked a minimum of 1,250 hours within those last 12 months. So now some qualifying reasons for FMLA. As Liz already mentioned, leave related to pregnancy is one of them. In general, birth, adoption, or foster care would also count. Caring for a family member who has a very serious health condition, an employee's own serious health condition, military qualifying exigency leave, which that is when you get into a little bit longer of a potential FMLA leave, and a care for a military family member who has an injury or illness. So how do employers recognize that their employee needs to take leave? And this can be tricky. There's not one, factor unless your employee comes to you directly and says, hey, I have this going on, I need this. Sometimes they could be trying to push through or don't know that they qualify or are afraid to say anything. So typically when employers start to notice that their timesheets look different, there's poor attendance, someone is about to be disciplined for whatever reason at work, they continuously ask for changes to their schedule, as they might need to continuously attend doctor's appointments. they might bring up, oh, my mom has been in the hospital a few times, hoping that someone will latch on to that, realizing that they do need to take time off. Or, and probably one of the easier ones, is a workers' comp situation where an employee is hurt on the job and they need time to recover.
Right. I find it, interesting how often the need for leave comes up when there's a corresponding disciplinary action that is about to be taken. And I can't tell you how many times I talk to employers about the fact that they have an employee who's now out on FMLA, but they had all these issues with them before they went out. And a lot of times those issues are undocumented. And so the employer's like, well, now I have this, employee who's been out for a long time. When they come back, I'm not looking forward to this continuation of issues that may have existed before. And so I think it's important at this point to just put in a little reminder that if you are seeing, issues with work performance, it's okay to discipline people for not doing their jobs. But if they are bringing up issues where they do need leave, I do think it's important to, of course, explore whether or not they need the FMLA and they qualify for that. But that doesn't mean that, the issues that are out there are, things that have to be ignored. You can still discipline people on a consistent basis for not meeting the requirements of their job. And a lot of times that's really important when down the road you may want to take additional action. But it really gets tricky when you have this FMLA time off and being sure that you appropriately make decisions for bringing them back in compliance with the law, and making sure that you're cognizant of, those next steps, and maybe resetting some expectations when they do come back to work. Like, here's, some of the things that we dealt with before, but we want to make sure that going forward, we can resolve those, and so I think those are just some things to keep in mind whenever I'm looking at lists like these, to just know, as you navigate the FMLA process. It doesn't mean that you can't also hold people to standards. You just also need to make sure that you're holding yourself to the standards that are set forth in the law and comply with those. So, sorry, Megan, a bit of a tangent
just
for you.
before we move on, to build on that, is, if you have an employee who has been an absolute rock star and then all of a sudden, they're coming in a little bit late or they seem distracted, sometimes it's as simple as saying, hey, just checking in, before something starts to spiral, before they get into, significant disciplinary, measures, where you say, hey, just wanted to check in, noticed a few changes, just making sure you're okay. They might not always respond to that. They might say, no, I'm fine, it's fine. But it's still giving them that opportunity to open up and noticing that something might be off.
Right. Absolutely. I think that's excellent advice, Megan. It's always important, those relationships that you have and build with your employees, that can avoid a lot of issues when you do have additional things like FMLA going on, to have that open door policy and to be checking in with your team, and cognizant of what's happening with them. So, all right, without further ado, Megan, please continue.
Yeah, so we've mentioned there's medical reasons for FMLA, and as with any law, there is some definitions involved for what a serious health condition is. So under the FMLA, a serious health condition is an illness, injury, impairment, or a physical or mental condition that involves an overnight stay in a hospital, hospice, or residential medical care facility, and subsequent treatment that is connected to that original overnight stay. Any period of incapacity, which would include an ability to perform regular work duties for more than 3 consecutive calendar days, and any treatment, again, related back to that period of incapacity. 2 treatments, with a treatment defined as an in-person visit to a healthcare provider. 1 treatment by a healthcare provider who prescribes continuing treatment, and periodic incapacity due to pregnancy, including morning sickness or parental care. So the definition is pretty broad for what is a serious health condition under the FMLA. And more often than not, I'm finding that if someone is seeing a doctor in continuous care, that is seen as serious, even if it's not necessarily a condition that the world itself sees as serious, but that just enough continuing treatment will have someone qualify.
Right. And, on that note, when we're talking about serious health conditions, sometimes those chronic health conditions can qualify as FMLA. And chronic conditions can be things like migraines or depression or diabetes, things that may be manageable on a day-to-day basis for a lot of employees who might have, migraines, but they're able to, manage or work. However, those could be chronic conditions depending on, how they're impacting that employee, that might make it so that they qualify for FMLA leave, either on maybe an intermittent basis or, on a consecutive basis. But if it's a chronic condition, you're going to be looking at something that requires at least 2 visits per year to a healthcare provider for treatment, something that continues over an extended period of time, and something that can cause episodic incapacity. And I think that the examples that we gave, like migraines and depression, are certainly ones where we can see that ongoing need for treatment, the ongoing need for potentially episodes that pop up. So those are things to keep in mind. Additionally, you could have permanent or long-term incapacity as a result of treatment that might not be effective. For example, if you're being treated for Alzheimer's disease, perhaps it is just not, going well, or, there may be a need to step away from work to address, the ongoing health condition. And then there are conditions that require an absence to receive multiple treatments, such as having restorative surgery after an accident or injury, or a condition that without medical intervention would most likely cause a period of incapacity for more than 3 consecutive calendar days, such as cancer. So I just think those are some real life examples to be thinking about in terms of a need for FMLA. All right. So in terms of how the leaves work and the amount of the leaves, FMLA can be taken in blocks of leave. You can have something like an intermittent schedule or a reduced schedule. So maybe the employee normally would work a 40-hour week, but maybe for a period of time they can only do 20. And so they'll take, that additional 20 hours that they would be working each week as FMLA time. They can do that. It can be in hours or partial work weeks based on the employee's regular work schedule. And you want to, make sure that you're tracking that time. If there is an intermittent FMLA need, that you're properly basing it on what they work, how many hours they normally work, in determining whether or not they've been given all the time that they're entitled to under FMLA. And then you also want to watch out for requests that may be incorrectly considered accommodation issues, such as the employee says, hey, my doctor says I can only work 20 hours a week. And maybe the supervisor responds and says, we can't accommodate that, or we don't have part-time jobs. It's just important to see that as something that indicates that there might be a need to offer FMLA. And you don't want to say, no, we can't do that, without, first evaluating whether or not they're entitled to, some kind of intermittent or long-term FMLA leave. So this is a form of FMLA if someone is eligible.
Yep. So what happens, after that 12-week period and an employee can't come back? But before that, maybe they can. And so when an employee is coming back from FMLA, they're entitled to that reinstatement to their same or equivalent position from when they took their FMLA. So that would be virtually identical. So same pay, same shift, same benefits, same worksite duties, etc. Can they perform the essential function of the job? And just that reminder that undue hardship, like Liz was mentioning on the last slide, sometimes employees don't know that they're asking for FMLA, and recognizing that it's a request for FMLA versus an accommodation request under the ADA is key to remembering FMLA does not care if it's an undue hardship. It is a must, a federal protected leave opportunity for employees. There's also no greater right for employees returning. So something, that can come up a lot is an employee feels that they put in enough time, they deserve a higher position, even though they have been out, but that is not something that they are entitled to. It's, again, that virtually identical same pay, and then the reminder that it is also very risky to terminate someone, and as we mentioned before, there might have been those performance issues leading up to someone taking leave, but it is a very high risk to an employer to terminate someone returning while they're on FMLA or very close to their return.
Right. Can't highlight that one enough. It happens more often than you think. All right. Thank you, Megan, for covering that. So moving on. So what if they can't come back after these 12 weeks? What does the employer do?
Yep, so that is where potential leave under the ADA comes in. And so leave is only one form of a reasonable accommodation under the Americans with Disabilities Act. Sometimes when someone comes back after FMLA ends, they're trying to come back, or the employer is looking for that individual to come back. And they say, oh, well, I haven't been cleared fully to come back by my doctor. So that's when an employer can start to engage in that interactive process to say, hey, well, what can you do? And using leave under the ADA as that last resort type of accommodation. So what is the ADA? The Americans with Disabilities Act, I feel like that is used a lot. Oh, it's protected under the ADA, and a lot of people will throw that around. Again, it's another federal layer of protection. It prohibits discriminatory behavior towards an individual due to their disability, their history of having a disability, or because they're perceived as having a disability. Employers must reasonably accommodate qualified individuals, and this is where that undue hardship comes in. There is an interactive process where an employer should engage with their employee, possibly the healthcare provider, if necessary, to figure out what will work best for everyone moving forward. It's also important to remember that unlike the FMLA, that's very much a standard time off, no time off, protected time off, accommodations under the ADA are very, very individualized and are very fact-specific to the individual requesting them. And so someone who, oh, they had surgery and their doctor said, no, you can't come back yet. Well, can they work from home? Is that an option? Instead of having to drive into the office. I know personally I've had a whole host of knee injuries, so sometimes driving isn't the best option for me. And so that could, be someone else's situation. And while they think, oh, I can't come into work for another 3 weeks, if they have a laptop, issued by the employer, then it's a possibility that the accommodation is just work from home. That might not work for every employer and every employee, but something to keep in mind before that blanket ADA leave accommodation.
Right. Right. And I do think, it's important to, one, understand the need to engage in that process. So it is a back and forth. It's a conversation. It's I don't want to say negotiation, but it can't be a negotiation at times. It might be the employee comes and says, hey, I was out on FMLA. I need 2 more weeks. Like, are you okay with that? And you're like, sure, no problem. Like, that works. Or it could be they come back and they say, hey, I, need another 8 weeks. And you say, oh, I don't know. Maybe that is an undue hardship on the business. And maybe, with talking to them and kind of figuring out, maybe it's something where, you give them an additional 2 weeks and then they work from home for those, remaining time. And maybe that's something that is a middle ground that you guys can come to that works for the business and works for the employee. And so that, I think, is an opportunity to reach across the table, talk to your employee, and figure out, is there a path forward that could work for both the employer and the employee? So I think that's, something that a lot of employers just, don't engage in that process, and it is such a crucial point of the FMLA dynamics. So
Yeah, so now that we've talked about the, big picture, let's talk about those practical steps that you as an employer can take, especially when someone is, running out of FMLA. What do you do? So typically you have from the start of their leave, we'll have a tentative idea of their return to work date or a tentative return to work date. And so then once you're getting a little bit closer, it's a pretty good idea to just reach out to that person, check on them, their status, and their return to work plans. It can be as simple as, hey, we have down your intended return to work is this date. Is that still the target for you? Just checking in on them and making sure that they're either ready to return or providing them that opportunity to say, hey, something else, happened, or hey, this isn't going as well as I thought, need a little bit more time. Right. So from there, right, if they need a little bit more time, or even if you're waiting for a doctor's note to clear them fully for return to work, as the employer, you can request, new or updated, information from the healthcare provider to either say, yes, they're cleared from work, or no, they need an additional X amount of time off, or they can return with accommodations. Most physicians will put some language like that together. Mm-hmm. And then, as they're coming back, to really outline with the employee, what they can or cannot do if they do need an additional time or an additional accommodation to return. And it's really setting those expectations or reestablishing new expectations once that initial leave time has expired. And then, if the employee is in agreement, great. It might take a while to get to that agreement. Sometimes they're still thinking, oh, I still need this time off, et cetera. But with that interactive process, it's pretty easy to close that gap. And then, as we said before, don't really move towards, a leave accommodation as the first choice. Go through that interactive process, talk through potential options that work for your business and that could work for the employee. If, they're saying, oh, I can only work 20 hours a week, is that, split into half days? Is that they only work a few days per week and have the other days off for that leave accommodation, et cetera? Can they, not lift something and that's part of their job? Those types of accommodations first before that blanket another 3 to 4 weeks of time off.
Right. All right. So let's talk about the Pregnant Workers Fairness Act. So this is a new law. It just went into effect, I believe, last year, right, Megan? Feel free to correct me on
Yep.
that one. But it's just that another layer of protection for the employees who may be impacted by pregnancy or pregnancy-related medical conditions, including childbirth. And the goal of this PWFA is not to replace or override FMLA or ADA, but it is basically to provide covered employers with reasonable accommodations to a worker's known limitations related to pregnancy, childbirth, or related medical conditions, unless the accommodation will cause the employer an undue hardship. So the thing about this law, as in comparison to, for example, FMLA, is there is a lower threshold for an employee count. So this law is applicable to both public employers and private employers with at least 15 employees. And so it's a pretty low threshold, but the goal of the law really is to allow for some reasonable accommodations for people who are experiencing these temporary conditions related to pregnancy. And some of the things that the law outlines as examples of reasonable accommodations are things like maybe closer parking. I think we see that at stores like Target, where they have the little store, sign where, pregnant women can park closer and walk in. The same kind of thing could be used in the workplace. Maybe they need to be able to sit more or to take more bathroom breaks or, be able to step away for more rest. And maybe they need to take time off, so maybe they don't qualify for FMLA based on your employer size, but maybe they still need time off to recover from childbirth. Those are things that may need to be accommodated under this law. And, there may need to be some changes to some of the things that they normally would do, like heavy lifting. And so there's a variety of things that could be implicated here. And I think, again, that goes back to having that conversation, with your employees and having that open line of communication. If you have an employee who's indicated, hey, I'm pregnant, and I might need some changes done, that's an opening to say, okay, like, what can we do to help you? Or what do you need in order to be able to still be able to, work for us and do the job that we have for you? And again, I think it's an opportunity to work with the employee to find some practical, steps forward for them so that they can do their job. So the question becomes, is the PWFA just another version of the ADA? And the answer is no. I mean, there are some similarities, there are some differences, and then there are some key differences. So we're going to cover those briefly. So the similarities are going to be that interactive process that I was just talking about. Coming up with a reasonable accommodation that works for both, you and the employee, and that ability to assert that allowing certain accommodations might be an undue hardship on the employer. So all of those things mirror the ADA. However, there are some distinctions. For example, there's no requirement of impairment that substantially limits a major life activity. So, under the ADA, you're looking at something that's really debilitating, that's really impacting the employee over a long period of time. Pregnancy and pregnancy-related issues are usually temporary in nature. So you're not going to have to be able, as the employee, to establish that this is a long-term thing, because it's not. So it also may not require an employee to take a paid or unpaid leave if another reasonable accommodation is available. So that would be some distinctions. It's not necessarily a free-for-all in terms of taking time off. So some key differences, though, are you must accommodate even if the employee is unable to perform the essential functions of their job for a temporary period. So, as long as they can, again, be able to pick up and do the things that they, have normally been able to do in the near future, then it's something that you need to work with them on. So, Megan, feel free to correct me if I got any of that, not quite on point, but those are the similarities and the distinctions as I see them.
Yeah. And it's definitely something, again, that federal level protection where, and we'll get into it, soon with the state and local laws, but from a federal level, this stance to, and especially lowering it to 15 employees, really shows that there was a gap between both the FMLA and the ADA that this law is coming in to fill, so that, someone might not need to exhaust their time under FMLA because they qualify for, under the Pregnancy Workers Fairness Act.
Right. Absolutely. I think that this law is on trend with what we're seeing on the federal level. The FMLA is enforced by the Department of Labor, in terms of that time off. The ADA is enforced by the EEOC, and I think that for the past several years, pregnancy has been a hot topic, and the ability to ensure that pregnant women are not discriminated against and that they are accommodated in the workplace has been a hot topic. So I think this law is a reflection directly of that, and as you said, of the gaps in the different protections that were already there. So interesting times that we live in. There's always a new law to keep up with, to be thinking about as you navigate the workplace. So on that note, let's talk about those state and local laws that add that additional layer of complexity as we navigate these, these issues. So first and foremost, how do state laws interact with these federal laws? And most states and even some cities have their own laws like paid sick leave, paid family leave, and sometimes they require things like short-term disability leave and other types of benefits to the employees that interact, and sometimes run with these federal laws. Sometimes they are kind of have their own rules and procedures for enacting. So it really adds that layer of complexity for an employer as you navigate these additional laws that are out there. But it's important to remember that these federal laws are the baseline expectations for employers who are, the size required by each of those laws. And that these cities and states often can impose laws offering more protections than the federal law. And there's I think, depending on the state or the state specific law, there are options for paid or unpaid leave. There's leave that can run concurrent with the FMLA, and then there's leave that does not run concurrent with the FMLA. And I think we see that a lot in our friendly employee states like California, with our many different laws to navigate.
Mm-hmm.
And so when you have an employee come to you and they say, hey, I need leave, you really need to be thinking in terms of what state laws in the state that the employee is working in that may be impacted and that the employee may have available to them. I also think it's important that a lot of these states have paid family leave, and that doesn't necessarily extend to the employee. That's a paid family leave. It's designed to be used so that they can care for a family member or some other type of, situation. So there are a lot of nuances that can come into play where an employee, may be entitled to FMLA for their own condition, but not paid family leave under a state law because of the logistics and the requirements of the law. So there can be a lot going on, but anytime that you can make these laws run concurrent with each other, you're definitely going to want to, so that you don't run into a situation where you've offered somebody FMLA and now you also then have to offer them an additional potentially 12 weeks of paid family leave. You want to make sure that if you can make them run concurrently, that is established on the front end, and is clear to the employee, so that you as the employer can limit the amount of time that they are out.
Yep. And so as we've, said, and continuing on with what Liz was saying, is that sometimes, as an employer, you're just too small and FMLA, is not applicable. And so that's really where a lot of these state laws come into play, especially some of the city laws, where they're going to be anywhere from, I've seen a 5 to 10 employee count, to really make sure that the employees in their states are protected. Again, most of these state and local laws have a set duration of time. Typically, it's similar to FMLA, where it is at 12 weeks, some a little more, some a little less, depending on the nuances of each state law. And again, should someone exhaust that protected leave, there's again the opportunity for the interactive process and the ADA to come in, even on the back end of someone taking leave under a state law. I know some of the states that we are very familiar with that have a few more of these leave laws would be New York and New York City, California. A lot of the counties in California, like San Diego County, has its own specific leave laws that are even a little tighter than the state of California. Massachusetts has its PFL program. Minnesota has a pretty robust program that some cities like Duluth and Minneapolis have, again, a bit stricter law in place for who qualifies and how much time they get. And then Oregon as well has its own program.
Yeah, and I think more and more we'll see states enacting their own levels of these leaves, and whether at some point the federal government will step in and say, okay, we're going to establish one standard for everybody, I think is likely not going to happen anytime soon. So I think we'll just continue to see state and localities kind of take their own measures to extend the benefits that they think that the employees in their states should have.
Yep. So as, employers, what should you do when one of your employees needs a leave accommodation? So since you are with us on this call today, right, on this webinar, one of the first things, have that conversation with your employee first and foremost, and then reach out to your assigned HRBP with Prestige. They can help guide you and provide you with next steps, as well as looping in our internal team on Prestige so that we can, help guide you with that leave process. And then for your employees, feel free to let them know that someone will be reaching out to them, to discuss anything further, or if there's any additional questions, and we can help with that process.
Right. Absolutely. And we can help with the paperwork. We can help with understanding the logistics of all the different laws that might be implicated with that specific issue with the employee. So we're really here to help, help you navigate something that can be complex so that your employees get, all the things that they need in a timely manner, and that you have all the tools that you need to successfully offer them leave and approve it, and make sure that they are on the road to hopefully a successful recovery from their need for time off and their ability to come back to work, hopefully in a timely manner. So let's talk about some takeaways from all of this information in terms of, these different laws. And so just, as a reminder, federal laws offering leave and job protection to employees are the minimum, and those states and cities can offer more protections. Some employees or employers may qualify under both those federal and state laws. So it's important to be cognizant of both of them. And keep in mind that just because someone has exhausted their 12 weeks of FMLA does not mean that they do not have any other options if they're not able to return to work. There may be some additional obligations for you as the employer that you may need to undertake. And then federal and state laws do not provide unlimited protected leave for employees and typically have set durations of weeks for protected leave. So I do think it's important to point out that I'm not aware of any, state or federal, law that just says an employee can stay out indefinitely and that's just it. And the employer just has to leave their position open indefinitely for them. That's not practical. I think, most state and federal, regulators understand that at some point, if an employee cannot return, there does have to be an end to that time off accommodation that might be there or the leave that they might be entitled to. And so it is intended to limit it so it's not something that is ongoing. But certainly if your employee has indicated that there is an end date, that's something you need to be considering and thinking about and having that interactive process with to determine if that's something that you can accommodate, if it's an ADA issue, and then making sure that you've complied if it's an FMLA or other state protected leave.
Yeah. So some of, the importance of knowing of these, leave and accommodation laws is that, long-term remote work since, the height of COVID has, really put sort of a wrench, right, in some of these accommodation requests where before COVID, it was sort of few and far between depending on the technical sophistication of a company. Was everyone issued a laptop, et cetera? But since COVID and that turn towards long-term remote work, I've definitely seen the trend where, a work from home accommodation is going to be where courts don't see an issue as much anymore and don't really view that as an undue hardship to an employer. Especially with the technology and how everyone, pretty much fully went remote during the pandemic. And then EEOC, as, Liz mentioned before, there are an increased trend for violations of whether it's ADA or not providing proper, leave, whether it's at the federal or state level on the basis of disability. Those have definitely been on the rise, and so being aware of both the federal, state, and local laws can help mitigate your risk as an employer to avoid, a charge coming your way. They're now, with the introduction of some newer laws like the PWFA, there are additional factors and, lenses being looked at for, was it an accommodation? Should it have been supplied to them under the PWFA? Was this an FMLA issue? Was this a, New York disability issue? And so with, a little bit of a stricter lens, I would say, is the trend I'm seeing with the protection for employees. It's really important to, at least be familiar that these laws exist and once something arises in your own business to then say, maybe I should look at this a little bit deeper. Maybe I should give Prestige a call and see if they can help me.
Right. Because we do want to, partner with our clients to help them be as compliant as possible. And, we understand these things can get complicated quickly. And so I think there's a couple of things that just as we, prepared for the webinar and we're thinking through some of the issues that, we see on a regular basis, I do think that there's like a couple of things that, if I was an employer, I would kind of be wondering about. And one of them is like, how would I know that if it's an ADA issue, that the leave accommodation that I've given is sufficient? And I think that goes back to that interactive process and making sure that the communication with the employee is clear. And that also, if needed, it's supported by the medical documentation showing that the employee does indeed need to be out for an extended period of time if that's the case. But that communication is so key as you talk to employees. I think another thing to keep in mind is that a lot of times employers kind of miss their opportunity to designate time off as FMLA. And so I think it's important that once you're on notice that an employee may need FMLA, that you're moving quickly because you need to be able to provide them with an FMLA packet within, I believe, 5 days of finding out that they may need the time off. And then they have a specific amount of time, and it's 15 days, to be able to return that packet to you so that you can evaluate the need for the time off. You know, it shouldn't be retroactively designated as FMLA. You should be, you know, as soon as you know the need of it, that you're preparing that paperwork and getting it out, and we can help with that. And then, you know, just again, keep in mind if you're too small for FMLA, that you're still checking in and making sure that those state-specific laws aren't applicable to you. Or, you know, if you have a pregnant employee or someone with a pregnancy-related condition, or, you know, potentially a disability, that you're looking at those smaller thresholds for, you know, the Pregnancy Fairness, Workers Fairness Act, or the ADA as well. So, I mean, those are just some tips on my end. Megan, I don't know if you have any other, you know, tips as well for our viewers.
Certainly. I would say, you know, just to build on that, right, with different accommodation requests, it doesn't, right, like we say, it doesn't have to be time off. It doesn't have to be work from home. Sometimes it's as simple as providing a standing desk to someone who might have had a back issue, but giving them the ability to sit and stand throughout the day can help alleviate and mitigate their issue in the workplace.
Right.
And rather than that keeping them out an additional time, it's something that can get them back to work, and so that you as the employer don't have someone out indefinitely.
All right. Well, on that note, Carrie, I'm going to pass it back to you. You know, if there are any questions or comments, happy to take those. Otherwise, we're happy to follow up, you know, post-webinar directly with any inquiries that we've received.
Yeah, this has been great. Thank you so much, Liz and Megan. We did have a few questions come in, but let's review those, and then we'll reach back out to these folks on an individual basis.
Okay.
Due to an essence of time.
Okay.
So, but thank you everybody who joined us today. The recording of this webinar is available on our website at prestigepeo.com/webinars. Just give us about 24 hours to get that up for you. If you have any further questions, feel free to contact your Human Resources business partner for further assistance, and stay updated on compliance alerts by visiting our Compliance Center at prestigepeo.com/compliance-updates. And don't forget to check your inbox for our monthly Insights newsletter, delivering the latest HR news. Thank you all, and we look forward to seeing you next time.